recording. It's a quasi judicial hearing for Ian and Cali Klotz for a special use permit for a Class A manufactured home. I wanted to let the board know that, and those in attendance that are for this hearing, that we do only have 4 members present tonight, so it is a 4/5 vote, which means that all parties would have to vote in affirmative for the motion. You want me to say that?
Yeah, if any of the applicants that are here tonight for hearing, if you would prefer to continue your application until the next board meeting, if you would prefer to have more board members, that is your right to do so. You just need to let us know, otherwise we can proceed because we do have enough for a quorum to vote, but it would require a unanimous vote. Whereas if there were more board members, it would only require a 4/5. So just letting you know that because it's your decision to make. Otherwise, just let us know when we call your application if you want to proceed forward today or if you'd like to continue it. Okay.
Is that just for the ones, the applicants, right? Yeah.
Yes.
Okay.
And I believe, we have Ms. Kathy Schaefer here representing the applicant. She's their realtor.
Okay.
So she'll be able to speak on behalf
Okay.
of Ian and Cali.
This hearing will be conducted by the Planning and Zoning Board, also serving as Board of Adjustments. My name is Carter Burns, and I am the Chair of the Board of Adjustments. Would the board members please go around and state their name for the record?
Jeannie Russell.
Jones Laughlin.
Lisa Brock.
Attorney Misty Whitman will be advising the board on legal and procedural questions. Angel Jenkins, Town Manager and Zoning Officer, is serving as staff of the board today. If you wish to speak as a witness today, you can find the sign-up sheet at the podium or up here. Special Use Permit 2026014, request by Ian Klotz and Cali Klotz for special use permit to place a Class A manufactured home on their parcel located on Sturdivant Road. This parcel is in the RA zoning district. The public hearing is for special use permit, case number 2026020, applicant Ian Klotz and Cali Klotz, parcel number 07033800000022D, pin 6669-04-60-8227. The decision will be made by 4/5 vote of the board. The hearing is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. The rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. Participation is limited. This meeting is open to the public and everyone is welcome to watch. Parties withstanding have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, local government, and individuals who can show they will suffer special damages. Other individuals may serve as witnesses when called by the board. General witness testimony is limited to facts, not opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide factual evidence upon which they base their expert opinion. Witnesses must swear or affirm their testimony. At this time, we would administer the oath for all individuals who intend to provide witness testimony. As a reminder, witnesses should provide factual testimony as to how this project does or does not meet the standards. The board must base its decision upon evidence in the record, not personal preference or opinion. Please be aware that the applicant and other parties have certain rights to object to your testimony and cross-examine you as a witness. The board, though, will determine what evidence to consider and how much weight to assign to it. Witnesses must swear or affirm their testimony. At this time, we will administer the oath for all individuals who intend to provide witness testimony.
So if I have anyone who intends to speak for or against this at this hearing, please come forward. I'll come forward, left hand on, raise your right. One more in, left hand on, raise your right. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Parties to this case are entitled to an impartial board. A board member may not participate in this hearing if she or he has a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close relationship with an affected person. Does any board member have any partiality to disclose and recusal to offer? The parties to this case have rights for an ex parte communication to be disclosed. Ex parte communication is any communication about the case outside of the hearing. That may include site visits as well as conversations with parties, staff, or general public. Does any board member have any site visits to disclose? I rode past the site Saturday. Just rode past to get reacclimated with it, so I'll disclose that.
Mine was on Sunday, I rode past for some reason.
I rode past a couple of weeks ago.
Based on the disclosure we've heard from the board concerning partiality and ex parte communication, does any member of the board or any party to this matter have any objection to a board member's participation in this hearing? Ms. Jenkins will read the application, give the summary, and introduce the applicant.
Thank you, Chair and board members. We've received an application for a special use permit from Ian Klotz and Cali Klotz, Lineage Land LLC. And the property is owned by Brianna Collins and Zach Collins. The property is located at 242 Sturdivant Road, in Denton County, and in our ETJ. It is in the zoning classification RA. Reason for a special use permit request stated that we are requesting a special use permit to place a new HUD compliant manufactured home on the property located at 242 Sturdivant Road for the purpose of providing affordable housing to the Denton community. Special use description, it asks applicant's description as to why the special use permit is needed. Due to the zoning regulations, in order to place a new manufactured home, special use permit is required. The applicant seeks to place a new HUD compliant manufactured home on the property at 242 Sturdivant Road. The home will meet all applicable setbacks, aesthetics, and installation requirements as set forth in Town of Denton zoning requirements. For relevant facts, number one, the use will not materially endanger the public health or safety if located where proposed and developed according to the plan as submitted and approved. And the statement from the applicant is the placement of a new HUD compliant manufactured home will not endanger public health or safety. The home will be installed per all applicable state and local installation standards, connected to an approved wastewater system, and will meet all required setbacks from property lines and the road. Number two, finding of fact is the use meets all required conditions and specifications of the permit. And their statement is that the proposed use meets all required conditions and specifications of the town special use permit. The home will be a new manufactured home meeting HUD construction standards, installed on an approved foundation, and will comply with all applicable requirements and aesthetic standards. Fact three, the use will not substantially injure the value of adjoining or abutting property or the use of public necessity. statement from the applicant is the placement of a new manufactured home will not injure the value of adjoining or abutting property. The home will be newly constructed, HUD compliant, and will be well maintained in appearance. Furthermore, the addition of quality, affordable housing serves as a public necessity by expanding attainable housing options for working families in the Denton community. Fact 4 is the location and character of use. If developed according to the plan as submitted and approved, will be in harmony with the area in which it is to be located and in general conformity with the plan of development of the town and its environs. And their statement is that the location and character of the proposed use is in harmony with the surrounding area. Manufactured homes are permitted use within the zoning district with a special use permit consistent with the town's development plan. The placement of new home on this property aligns with the residential character of the area and also supports the town's goals of providing diverse and affordable housing options to its residents. And this was submitted on May the 18th, 2026 by Mr. Klotz. In reviewing of the application, in order to place a manufactured Class A home, they do have to meet certain standards for the underpinning of the property, so that you already have those conditions set up in your zoning. If I can find that in my notes, I will read that to you. My apologies. So, in compliance with your zoning ordinance, you already require that a manufactured home has a length not exceeding 4 times its width, the length measured along the longest axle and widest measurement at the narrowest point of all other axles. A manufactured home has a minimum of 1,200 square feet of an enclosed heated living area. The pitch of the roof in a manufactured home has a minimal vertical rise of 3 1/2 feet for every 12 feet of horizontal run, and the roof is finished with a type of shingle that is commonly used in standard residential construction. All roof structures shall provide an eave projection of no less than 6 inches, which may also include a gutter. Exterior siding consists predominantly of vinyl or aluminum horizontally lapped siding, whose reflectivity does not exceed that of a flat white paint, wood or hardboard comparable in composition, appearance, and doably to the exterior siding commonly used in standard residential construction. The manufactured home is also set up in accordance with the standards set by the North Carolina Department of Insurance. You do require that stairs, porches, entrance platforms, ramps, and other means of entrance and exit to and from the home shall be installed or constructed in accordance with the standards by the North Carolina Department of Insurance and attached firmly to the primary structure and anchored securely to the ground. Removing the hitch, wheels, and axle, and transporting lights have been removed. A continuous permanent masonry, curtain wall, or foundation, unpierced except for ventilation and access, is installed under the manufactured home. It's the intent of this criteria to ensure that your Class A manufactured home, when installed, shall have substantially the appearance of an on-site conventional built single-family dwelling. Staff assessment is that the proposed home type is inconsistent with the ordinance definition of a Class A manufactured home. The RA district does allow for a Class A manufactured home by a special use permit. Appearance standards ensure that compatibility with the surrounding residential development and no adverse impacts on the public health and safety are anticipated if this home is installed per the North Carolina Department of Insurance standards and your zoning requirements. Staff recommendation is to approve the special use permit for the placement of Class A manufactured home. At this time, we will recognize Kathy Schaefer, who is representing the applicant.
If you will state your name and company and address, please.
Okay. I'm Kathy Schaefer, and I am a realtor with Real Broker. I represent the sellers, Brown and Zach Collins, and I'm speaking also on behalf of the buyers, which is Ian and Cali Klotz. The The address is for 242 Sturdivant Road. I have information, exhibits that I would like to provide you as I go over this, if that's acceptable.
Okay.
This is a land glide map, so you can see the property outline. And we'll go over that, that's the survey. And then there's renderings of what the home is going to look like and how it meets requirements or not.
Now, your property outline is different from what we have. Is there,
Well, that was the 10-acre parcel, but if you look over at the rendering, you'll see it outlined.
okay, so the red here is your outline. We need to focus on the outline that we have, which is just.
On the survey.
Okay.
But the aerial is to give you the 10-acre, because it was so newly surveyed that if you
Yep.
go to the land glide, it does not show that.
Okay, I just wanna make sure this additional is not like a future plan or.
No, it's not. No, so there on the first page that I've given you, the exhibit A, is the survey there, where a 1.14 acre has been carved out from a near 10 acre to be sold. And it is the buyer's intention to put a manufactured home there. And it is to be done by Champion Lake Manor, the Class A manufactured home, 2026 model. It's gonna be 1,490 square feet, and I see the requirement is a minimum of 1,200. If you look at the renderings there on Exhibit B, it's gonna outline that, given a layout of the land, so you can see the placement. It'll have a setback of approximately 250 feet off the road, where it will be private with the wood line up front. It won't be on top of any neighboring houses. And if you look at the land glide of the one map that I provided there, I would like for you to consider the aerial map that's displayed, which is showing the surrounding rural character, other larger parcels, wooded tracts, and existing homes in the area.
So for the site context, Ariel, is this essentially how they're gonna have this one laid out?
That's correct.
Okay.
Specific to that lot.
So pretty much as far as the trees being removed, it's gonna be minimal, just enough to
Very
put
minimal.
this. Okay.
That is the seller's, the buyer's intention, yes. And if you go to the very last page, Exhibit C, I've outlined the Class A requirements for you guys versus the proposed home.
The buyers, they're using this as a rental property, correct?
No, they,
Okay.
no, it's to be sold.
Okay,
As
just
a-
okay.
No, not rental property at all. It will be sold. And if you look at the proposed home that's outlined on Exhibit C, along with the rendering, you'll see that where they're saying that it must have residential exterior siding, they're going with vinyl siding, the permanent masonry foundation, they're having the permanent brick underpinning, permanent installation, permanent residence, permanent utility connections, utilities are planned, this is meant to be left in place. North Carolina installation standards, applicant representation, things that Angel has gone over. So to outline it, it's a 1.14 acre parcel, rural agricultural, mature hardwoods on there, there's a natural buffering. So at this point, what specific Class A requirements is not being satisfied by the applicant?
Any questions? Thank you. we have anyone wishing to speak for or against the special use permit?
Did we also see the rendering?
Yeah, I like to see the rendering.
Just give me 1 second, I'll call you up.
Okay, sorry.
Appreciate it. Angel, if you want to pass that. I'll give everybody a little bit to look at that, and I'll call first person.
Can I ask a question?
We'll call you up here in a little bit. Appreciate it.
Did you guys have a different view of the lot?
What we just handed you is what we were just handed.
Probably the GIS that we're thinking is what they may be talking
I
about.
think this is what he was referencing.
Yeah,
It's just the
okay.
GIS. It has it outlined. Some notes.
No, you didn't back to you.
Y'all ready to call the first person? Mr. Lowe Garner,
Here you go.
Thank you.
and if you'll state your name and address, please.
Okay.
And just to like to remind everybody, the testimony must be focused on factual evidence concerning the applicable standards. And then for the board, our decision is based on factual evidence, not personal opinion. So we just ask that you present the factual evidence that you have that would pertain in opposition of what's being requested.
Make sure it's standing.
James Lowe Garner, 204 Sturdivant Road, and also will be representing Mary Rose Glover of 454 Tamworth Drive. I'm the POA for her. She's not represented, she's 97, I'm a caregiver.
I think we'll limit
Okay,
your time just
Okay.
for you.
appreciate it. I just wanted to put that in there. Thank you, board. I have been living at my current residence for about 40 years now. I've had challenges at my home with runoff from the adjacent property. I've had to put in, I was cited by the Davidson County Health Department, so I had to put another septic drain field in later, approximately 10 years after I was living in. Also had to install a French drain on the east side of my property to divert the rainwater, and also grading that was done. I had to do a major investment in grading in around 1999. The property does have a challenge as far as, I'm not a soil scientist. I did speak to the soil scientist while he was out there. He said it was too rocky up the front, so I'm glad that they look like they placed the home further back now than when the original flags were put. They did have flags up in the original plot. It looks like, according to the way the septic system is going to be, they'll probably have to require an inexpensive septic pump system. So since this is challenging land and they're wanting to do affordable housing, it looks like it's going to be a lot of overhead for the initial investment of putting a house there. So that's just posing that toward the builders. Looks like the septic system will be probably directly behind my mother-in-law's. And I'm sure if it gets done through the health department, it's supposed to be within code, I understand that. But I just wanted to detail that there will be some challenges probably. I know that the soil scientists had to call in an excavator just to dig holes where fallen trees were to get good soil samples. And also I'd like to address the board concerning the first permit that was up here. And I want to,
Yeah, that one's already been closed out. So
okay, all right, that's why that president was not made, why that decision was not
Do you
followed
have any
through.
of the factual from the soil scientist, do you have any evidence?
No, I
to
just was
pertain?
speaking to him based on when he was out there and what his suggestions were. I was gonna try to obtain a report, I wasn't able to get that, so.
Okay.
But I mean, other than that, those are, my objections as far as that goes, as far as there might be a challenge to the ones building there with I have one more issue there. It's probably not gonna affect it now, but where they originally had the plot, there is a pile of rocks which represents a grave, on that site. And I haven't determined what that might be. So, and I think the soil scientist made note, he said he was making a note on his report. So, that's about all I think I can cover now, since I wasn't able to consider the other vote. And the issue with my mother-in-law was I think that the system would be directly behind her where all the good soil was dug up for the soil testing. And her bank is also kind of eroding now, so I've got to deal with that also.
All right.
Thank you.
Thank you. Any board member have any further questions?
For him.
Yeah.
Thank you.
Chair, if you will recognize the applicant's party as well, they may want a question.
Does the applicant have any rebuttal questions or comments for this witness?
I have comments. I need to state my name again.
No, ma'am.
In reference to his concern about the grading, anytime that you have to do like a perk test, it's not uncommon for an excavator to be brought in. That is not conclusive that there's gonna be more runoff issues or anything like that. That's just to make sure that you're getting to good bulk soil. So I don't see that as a dividing factor, and we don't have any factual knowledge of a grave site. And as for the rocks and the runoff, the grading is gonna have to be taking place to provide for this home that's going to address those issues. It's gonna eliminate those. So it won't be as it stands now when it's in its nature present to us. That's all I have.
Thank you.
Can I counter? I just was posing that there will probably be a challenge since I've had the experiences.
I appreciate it. Ms. Angie Floyd. And just state your name and address, please, ma'am.
Andrew Floyd, 822 Old Camp Road. For those members who were not here last time,
And just real quick, ma'am, we can't reference anything.
Okay.
That meeting's already been concluded.
I can't even tell why we sold the Collins the property.
This is a brand new hearing, so
Okay.
you can present your case based on
Okay.
facts.
All right.
And just to remind, it's facts that would counter any of the 4 points that they have to meet.
Okay. Well, I will state that I
She does.
object to this special use permit that's been filed. Reason number one, on the finding sheet that you have, the proposed house, I will not be in harmony with the neighborhood because we have no mobile homes there. All of the homes are contractor built. Reason number two, the finding number 3 on your paper, the application that this use will not affect adjoining property. Research I've done says differently. It may substantially affect adjoining property and property values. There could be maintenance issues, neglect of the property, and all of the things that go with mobile homes. I and my husband own the land across the street, which is at least 13 acres. Is this mobile home going to lessen the value of my property if I can't and will sell a building lot across the street one day in the acreage that we own? And there are new homes being constructed in town to provide housing. We don't need this mobile home in our neighborhood. I'm asking the council to reject the special use permit. Thank you.
board have any questions for that?
Ma'am, I have a question.
Okay.
Ma'am, do you have any, evidence from an appraiser or anything of that nature to quantify what you had indicated is potentially gonna happen to the value of the property?
I called one and she told me that she did not have time to do an appraisal before this meeting.
Okay, thank you.
Yes.
Applicants wish to have any comments or questions? Mr. David Snyder.
I just wanna, actually.
And just state your name and
David
address.
Sauter, 404 Sturdivant Road. So I actually have a little clarification that I need. So the statement that you guys read at first, that this was pretty much said, but apparently we can't talk about the other meeting that we had. So I would just kind of like to know the process. If one was denied, what was the process to go through?
What was the process on why hypothetically another meeting would have been denied?
If the request previously was denied.
So any
What
meeting
would-
that we have, it's those four standards,
Mhm.
they're voted on.
Right.
So, a combination of things could merit a denial of an application.
Mhm.
It could be that they didn't meet one of the criterias, or it could have been that the 4/5 majority did not pass.
Okay.
That's why any meeting would hypothetically be denied.
And what would have been the process if one was denied and someone wanted to challenge that?
You refile.
You just refile?
You can either appeal your existing decision
Mm-hmm.
or a new application can be filed.
So
This was a new application.
so it's a new application, so just to make sure that I'm right, so I understand you guys. So if in the future, if I choose to do something and it's voted down, I can keep opening a new application as many times as I want to until I get the answer I want, correct?
Based on new evidence, new expert testimony, all those things would play in a combination of such.
Mm-hmm.
So it's not a not a continual ongoing application process.
So I wouldn't have to do an appeal, I could just open a new application.
Well, and it depends. It depends on if you are dealing with a special use permit or if you're dealing with something else, because different ordinances have different requirements.
Okay,
Some of them
so
have timing,
let's keep it
some of
with
them don't.
special use then.
So this one in our ordinance, it does not have a time limit to reapply, so yes, you could reapply.
Okay, so I could reapply. So let's address the address concern, because 242 is for that 9 acres. Even though the other section has been cut off and does have a driveway, you know, my concern is if you guys approve this for 242, that does incorporate that other 9 acres.
This is strictly just that, the line that Angel showed you, that red box, rectangle, that's all we're discussing today.
Okay.
If I may, the address for that parcel will be developed from 911 once the property has been sold and a plan is submitted for building.
Okay, so it actually hasn't been sold yet.
It is pending.
It is pending, but on your website it's sold, correct?
Yeah, no, all
So I can't ask her a question, is what you're.
not right now. Yeah, all we're discussing today is just the red rectangle. And to Angel's point,
Yeah.
once the property is sold and then they'll develop the new address, it will now just be the red rectangle.
Okay.
That's all we're discussing.
Well, that's what all I'm
Yeah.
discussing. I'm just asking because it's pending, but yet it says it's sold.
Yeah, that might be something different, but that's not in regards to this meeting. But all we're looking at is the red rectangle.
That's what we're looking at, yes.
Yeah, and once
We understand that.
once we
Yeah.
make our decision,
Yeah.
then the property lines will be just the said rectangle.
Right,
That's all that's been brought to us.
okay, just the red rectangle for the company in Indiana to put a mobile home in Denton for the housing for.
Well, what we've heard is it'll be the is it the Collins, are they gonna be the buyers?
No, they're the sellers.
Oh,
The
Klotz.
owners of the property, Klotz will be purchasing.
Okay, so the Klotzes will be living there as a private dwelling.
They will not be living there. because they're in Indiana, which owns the company.
There's no relevance. to
Yeah,
it.
all we can base it off of what we've been.
I know, I just want the facts out before you do anything, so.
Yeah, but just to, and I'll make one more, so, and we did ask the realtor, it's not gonna be a rental property, it's gonna be a single family dwelling, it'll be living, primary residence.
Right. But they won't know the upkeep of it after it's sold.
Last comment I'll make, I mean, you could build a 5-story, 3,000 square foot home. We don't know what the upkeep will be with that too, so, any additional questions? Does,
Does she want to address his comments?
would you like to address any of the comments? Do the board members see a need for condition or conditions be placed upon applicant in the event the application is granted, and what such condition or conditions might that be?
Question, but I don't know if it's here or not. So my question would be, where are we with the PERC test and what's gonna be required for a wastewater system there? I mean, I know soil science has been out there, but do we have?
So all of that is handled through the county.
Okay.
So it will be septic because there's no sewer system available in that
Right.
area. It would be, it is in the Haney Sanitary Water District. So all of that would be established through the county, and I mean, it has to have a sewer system, a septic system. So they will give them the guidance on that as to whether or not a regular septic system is applicable for the property, or if there's other means that have to be made. There are, I can't think of, and Ms. Schaefer, do you have any information on that, on their septic system?
It'll be compliant and it did work.
It did perfect.
Because that was my question, because based on where it's at on the property, it's near the back of the property, and just, what, the setbacks and how close it can be to other property lines, that's why I was asking.
The board has now received all evidence and testimony. The hearing is now, can I leave this open until we discuss, just in case if we have any, because if I close it, we can't ask any additional questions.
Exactly, do your discussion first.
Okay. Let's see, so board members, board members, does any board member wish to discuss what we have heard and received? Now is our time to discuss. And if we have any questions, we can still ask because it's still open.
Sure.
So you've got right beside over the, you've got that old abandoned warehouse. And then you've got another home that's right down here. Go to the right there, I mean, it's in, to me, it's in harmony with what is presently there, based off of what is here.
Substation, that's true. There's a variety of things on the road.
So the big question I had was like a clear cut, but they would clear cut everything, and that could be a potential for ongoing purposes.
This, the site plan.
Yeah.
Looks like that's not the case. Which, that's where situations.
Can we, if we put a special use on the harmony, would it remain a single dwelling primary residence?
You can't restrict the rental, but you can.
No, well, not the, okay, take the primary residence, but a single dwelling. So that if, because they're being sold, they can't clear cut, because someone could buy and go, oh, I could fit one more back here,
Well, that would require a subdivision, and that would require.
so then they would come back, okay, so we're covered there. That's only that was, or not.
It doesn't fit.
Right. Any addition? has now received all evidence and testimony. The hearing is now closed, and the board must consider evidence and vote on the matter. If the board has no further questions or need for discussion, we must now begin the voting process on the finding standards. As a reminder, the board and those in attendance, North Carolina general statutes and our own town zoning ordinance requires a 4/5 majority vote in favor of the applicant on all 5 standards in order for the applicant's special use permit request to be approved. We have 4 voting members in attendance. A successful motion on each standard requires at least 4 affirmative votes. Standard number 1, with regard to standard number 1, the use will not materially endanger the public health or safety if located where proposed and developed according to the plan and submitted and approved. May I have a motion to approve or deny standard number 1? I'll make a motion to approve standard number 1.
Second.
Any need for further discussion? All in favor? Aye.
Aye.
All opposed? Standard number 2, with regard to standard number 2, the use meets all required conditions and specifications of the permit. May I have a motion to approve or deny standard number 2?
I move motion to approve.
Do I have a second? I'll second. Any need for further discussion? All in favor?
Aye.
All opposed? With regard to standard number 3, the use will not substantially injure the value of adjoining or abutting property or the use is a public necessity. May I have a motion to approve or deny standard number 3?
So moved to approve.
Do I have a second?
Second.
Any need for further discussion? All in favor? Aye.
Aye.
All opposed? With regard to standard number 4, the location and character of the use, if developed according to the plan as submitted and approved, will be in harmony with the area in which it is to be located and in general conformity with the plan and development of the town and its environs. May I have a motion to approve or deny standard number 4? I'll make a motion to approve standard number 4. Do I have a second?
Second.
Any need for further discussion? All in favor? Aye.
Aye.
All opposed? After voting on all 5 standards for the special use permit request, the board approved general standard number 1, approved general standard number 2, approved general standard number 3, and approved general standard number 4. And from a review of the votes of the board, all 5 standards were approved in favor of the applicant, and as such, in accordance with zoning ordinance and North Carolina law, we must approve the special use permit request. Do I have a motion for approval of the special use permit request by the applicant? I'll make a motion to approve the special use permit request by the applicant. Do I have a second?
Second.
All in favor?
Aye.
All opposed? The results are the special use permit for 2026, no. 2026-020 was approved by a vote of 4 in favor and 0 opposed.
No, I don't need it.
Yeah, what it said when I looked for this is what to do. That's, I said, well, I need to, like, cause I'd studied for it.
Attorney, is it standard procedure throughout North Carolina as far as the timeline for permits such as this, or is that according to the local zoning board, how they?
According to the local ordinance.
Okay.
And it varies widely across the state.
Okay, thanks for that answer. If they have to take up future measures, if there's a complaint filed for future measures, it should be a timeline for the reapplication. I suggest that they do that.
And I understand that in the near future, the planning board will be considering updates to the planning and zoning ordinances. And so what their suggestion is that there should be a time limit for reapplying afterwards, so it's something that you may want to consider moving forward.
Can you, understand the time limit, can you put quantity of times one applicant can make?
If they could reapply, I don't know, I'll find that answer out.
Because again, I mean, we can do the time, but if you have one person that applied 8 times, and it's not 8 times, I mean, seems like that would be
Expensive.
yeah.
It's expensive, yes. I'm not sure that you can limit their application times, but you can limit the amount of time between the applications, but I will look and get you an answer.
Can you, I know we've got one more, but can you structure the time where you say if you're denied, 1 to 3, it's such a time, and if it's more than 3, then now it's a longer time?
I will give you a memo on that and let you know what you can do.
Next. I need to start all that back over?
Well, it's not quasi judicial.
Oh, okay.
It's just
So we're
a public
just-
hearing. So
Okay.
you'll call, do you want me to start with a summary and then you can open your public hearing after that?
That would be great.
Okay. Alright, please.
Seated too long.
Mr. Anthony is here, asking for a rezoning request. His property is located at 18492 South Highway NC 109. And, it is currently zoned R15, and they're requesting to rezone to highway business. This property is located in a highway business district. Years ago, the board approved the quarter of 109 to be highway business, and some properties opted out and remained as a residential property. He is asking for this to be rezoned to highway business for the potential of, maybe could be still housing, or he could sell it for a business purpose. So, that is your request this evening, and, he is here if you would like to speak to him or ask him any questions on that.
Motion to open the public hearing.
So moved.
Second. All in favor, aye. Ready?
Yes, sir.
Any contact information you'd like to provide to us around your request?
He was expecting his realtor to be
Yeah,
here.
my realtor was supposed to be here, but she was not here. So this place is in the middle of businesses. Well, around 3 businesses.
Sure.
So it's gonna be impossible to sell it as a residential. So I mean, I feel like it'd be a great opportunity for a insurance company or someone that wanna start a office business. So that's the reason we wanna. She can advise me to change it to having commercial. Yeah. Okay.
I have a question.
Thank you.
Okay.
I can't ask. This is only based off of, it's the table, right? The highway business.
Correct. It'll be rezoning, so anything within that can be utilized once it's rezoned.
But I can't ask a question if someone has inquired to purchase it, like a specific individual.
Correct, you can't decision based on that.
Just curious. Any questions, concerns? I'll make a motion to approve the rezoning.
Mr. Chair, if you will close your public hearing.
Have a motion to close the public hearing.
So moved.
All in favor? I'll make a motion to approve the rezoning request from R15 to highway business for the property 18492 South North Carolina Highway 109.
Second.
All in favor?
Aye.
Thank you, sir.
Thank you. Thank you.
And don't forget we have a closed session.
Yep.
I was curious if Randy Queen was looking to buy it and expand his.
Maybe. But,
He's the one that owns the salvage yard right beside it that is in constant code violation for having things on the other side of the privacy gate fence that he's supposed to have.
Great.
So I was just curious if, but that's all I want to make sure of.
Are we finding him?
Gotta be in that. Paula, have we ever gotten to this, have we fined Randy or has he always complied before having to get fined?
Pretty much. It takes him a while though.
Okay.
Since I've been with the town, he has not been fined.
Okay, any copies of that closed session?
We need a motion for that? Or
Yes.
have a motion to open 5A closed session.
so moved.
All in favor?
Aye.